Cesny versus Cesny. Attorneys, may I get your appearances?
Caitlin Zilma on behalf of the plaintiff, the state of Judith Ann Cesny.
Ben Falick on behalf of the defendant, Lisa Cesny.
And Miss Cesny, would you please state your name for the record?
Lisa Ann Cesny.
All right. Good morning to all of the parties. We're here today for a motion to stay. Mr. Falick, go ahead.
Yes, Your Honor, we, following our motion for reconsideration, we are asking the court to stay the writ of eviction pending the defendant's appeal to the circuit court.
For what reasons? And I have read your motion, but I would like for you to place them on the record.
Yeah. Oh, so I don't, nothing to add in addition to what is in the motion, but the appeal will be as to whether the defendant was afforded her procedural rights at the Vice of Rights pretrial in December.
All right. And you have not filed an appeal yet, is that correct?
That is correct.
So it's just the motion for reconsideration and the motion to stay. And Mr. Falick, no transcripts have been ordered yet. Am I correct about that?
I would have to check with my office, but not that I'm aware of.
Okay. All right, Ms. Zellner, would you like to respond?
Yes, I oppose the motion. As stated, an appeal has not been filed. Also, I would just like to note we did file a motion for escrow yesterday. I'm not sure.
I see that.
Okay.
I received.
And then if an appeal should move forward, we'll be seeking a bond on appeal as well.
All right, so should there be an appeal filed, obviously we'll have to address the bond issue at that time. Right now, it's just we'll start with the motion for reconsideration on the basis of the process that was afforded to Ms. Cesny in this case. Mr. Falick, just by way of making a record, you work for Lakeshore Legal Aid. You agreed to, you screened Ms. Cesny. You took her on as a client, filed an appearance, and now we're here today. At our previous hearing, the court found judgment for possession for the plaintiff in this case based on a mediation settlement that Ms. Cesny entered into after she had a retained attorney, and this matter was settled through a matter in probate. There's a mediation settlement in this case whereby she agreed to vacate by November. Ms. Cesny stated on the record that she did engage in this mediation settlement, that she signed the agreement. She also stated on the record that she did not think she would actually have to leave, and that she thought that it would be more like February when she'd have to leave. And it became very apparent to this court throughout those proceedings, looking at the totality of the circumstances in this case, that Ms. Cesny had negotiated with her retained attorney in bad faith with the plaintiff in this case. This court allowed Lakeshore Legal Aid, Mr. Falick, allowed you to go into a breakout room where you spent over 35 minutes with the defendant in this case, interviewing her, screening her. And when you came back into the Zoom courtroom, this court tried to determine whether or not there was any triable issue in this case. And over the course of that hearing, this court determined that there was no triable issue in this case, and judgment was issued in favor of the plaintiff. Mr. Falick, as far as process in this case, again, this court afforded Lakeshore Legal Aid time with Ms. Cesny, over a half an hour in this case, which I will state for the record is not something that typically happens. Typically, Lakeshore Legal Aid is afforded 5 to 10 minutes with each defendant in this case. And we appreciate that Lakeshore Legal Aid is here. We at the 45th District Court firmly believe that it is important for indigent defendants to have access to counsel, even though there is no right to counsel in these cases. So we really appreciate that Lakeshore Legal Aid is here to provide counsel for our indigent defendants. This defendant received over a half an hour with you, Mr. Falick. I believe there was also some back and forth with the plaintiff's attorney. And I will also state, just by way of process, Mr. Falick, again, we are so grateful to have Lakeshore Legal Aid here. We do believe that indigent defendants should have some access to counsel, even though they don't have a right to it. We believe here at the 45th District Court that it is the right thing to do. I will say that, Lakeshore Legal Aid does not take everyone on. You do a screening process, and you evaluate whether or not they financially qualify for your services. And it is not the court's place to engage in any of any screening. That's up to Lakeshore Legal Aid to do. Over the course of this hearing, though, it was placed on the record that Ms. Cesney does live in a home in Huntington Woods that is valued at close to $1 million, that a trust has been set up for her through that probate proceeding that we discussed on the record, and also that she previously had an attorney of her own that she hired during the probate proceedings. So, Mr. Fay, I'm sure during the screening process, I don't know if Ms. Cesney represented any of that to you. That is between you and Ms. Cesney, and if there is any issue there, I'm sure Lakeshore Legal Aid will have to determine whether or not there's any recourse against Ms. Cesney. So again, this court allowed an inordinate amount of time for Lakeshore Legal Aid to interview Ms. Cesney. There was no tribal issue. Through the process of the hearing that was held here, it was abundantly clear to this court that Ms. Cesney negotiated in bad faith when she entered into that mediation settlement, and she had no intention of honoring that agreement, and there was, quite frankly, no tribal issue in this case. So the motion for reconsideration is denied. For the motion to stay, Mr. Falek, you have to demonstrate to the court that you're likely to succeed on appeal, which cannot be done here. Also, it looks like there's an abusive process here. There's no manifest injustice to the defendant. If anything, the defendant has taken advantage of process in this case. So the motion to stay is denied. Let's talk about the motion for escrow.
Yes, Your Honor. So we filed a motion.
Your Honor, if I may, briefly.
Go ahead, Mr. Falek.
As you said, the conversations that Lakeshore Legal Aid has in the Zoom breakout rooms, and again, we appreciate being afforded the opportunity to be present on the docket, are confidential and consist primarily in that half an hour of doing an extensive intake, not on the substance of the case, but initially to determine whether gather information, just demographic information, and to make sure that we, within our sometimes draconian funding parameters, can even advise, let alone represent the client. At the December pretrial, the defendant and I had approximately 5 minutes to speak. Not the legal assistant who did the initial intake. The defendant and I had, I would say, approximately 5 minutes to speak prior to being recalled back into the main court session. I didn't have an opportunity to speak in a breakout room with opposing counsel. Not that I'm necessarily entitled to that, but that is common under these circumstances. And I had no opportunity to review any of the documents to even advise, let alone represent the defendant. I hadn't yet filed my appearance. I did indicate that I would, and I subsequently did file my appearance. The tribal issue that we have since determined is whether the estate or members, and Ms. Cesney is an interested party in the estate, whether the other members in the estate interfered with Ms. Cesney's possessory interest in the property between the signing of the agreement and November in such a way that has made it more difficult for her to vacate, which is still her goal and her expectation. And again, whether that would be a winning, I'm sorry, whether that would be a winning issue, determining at the advice of rights hearing that there is no triable issue is an infringement on her due process, which is why we're seeking to take this matter to the circuit court, where I'm aware of no other court that issues judgments at the advice of rights. And that's why we want the circuit court to determine whether she was afforded her full due process.
Mr. Falek, you're still not putting any actual tribal issue on the record. You're making a blanket statement that there was some sort of interference with her possessory interest.
That's the tribal issue.
I was not served.
What happened? Ms. Cesney.
Your Honor, may I?
I'm sorry.
Hold on. Let me let Mr. Falek.
I'm sorry. I thought it was muted. I thought it was muted. I'm sorry. I was just saying I was never served this. I was never.
Ms. Cesney, I need to speak with your attorney. All right, Mr. Falek. When you say, I just want you to put on the record how what are the allegations that her possessory interest was interfered with? Because that was not placed in the motion.
Again, this is information I have been attempting to gather subsequent to the pretrial, but that first that it was not a bad faith negotiation, but that the Ms. Cesny relied on assurances from both parties that a November vacate date would afford her, or November in the agreement would afford her staying until February if she needed that amount of time, and then subsequent to
the agreement.
Ms. Zolna, hold on. Go ahead,
again,
Mr.
I'm not. I don't. We're not here to litigate that. I don't have witnesses or exhibits. What I was asking for, and that's why this is a procedural appeal, was an opportunity to have an evidentiary hearing so that the court could determine, after hearing under sworn testimony, which you did not have, they were not under oath at the pretrial, to determine whether there is not whether there's a trial, to have a trial that she's entitled to.
Mr. Falick, you're still stating these blanket accusations that her possessory interest has been interfered. You've now had a very long time to speak with Ms. Cesny. So she has had you as her attorney for quite some time, and there's still nothing that you are articulating on this record that presents a triable issue other than a blanket statement. So I would just, Mr. Falick, it's not there. Ms. Zolna, go ahead and respond.
Thank you, Your Honor. I just wanted to indicate that once the motion for reconsideration was filed, there was no additional proofs or evidence to support any of these claims, and none of these claims were even presented in the motion for reconsideration. I would presume after Mr. Falick had enough time to speak with the client that a motion for reconsideration would include some sort of additional proofs. There's nothing, because there is nothing, right? We have the settlement agreement. It says what it says. There's no caveat.
Which was acknowledged on the record by Ms. Cesny.
Exactly. There's no other carve out in it, or else that would have been present in the settlement agreement itself, and it is not.
All right. The motion for reconsideration is denied. The motion for stay is denied. Let's move on to the escrow order. Ms. Zolna, that's your motion. Go ahead.
I'm sorry, you cut out, Your Honor, on my end. Did you say motion for escrow?
Yes. Let's move on to the escrow order.
Okay, thank you. My apologies. So we filed this motion for escrow upon defendant filing this motion for stay. What it comes down to is the fact that this court granted judgment in favor of plaintiff regarding plaintiff's demand for property on December 23rd, 2024. Defendant filed a motion for reconsideration on January 1st. It was denied January 2nd. Defendant was required to vacate the premises by January 3rd, but she did not. This court entered an order of eviction on January 3rd. Defendant has yet to vacate the premises and has essentially put on the record that she has no intent to do so. So thus we are requesting that defendant escrow rent from December 23rd, 2024 until further order by the court in the amount we proposed of $7,163.25 per month and prorated, as the property has been valued at approximately $859,590 for the 4-bedroom and 3.5 bath property. We calculated the monthly rental payments at 10% of the property value, which comes to $85,959, and then divided by 12 months to arrive at the $7,163.25 figure.
I'm pulling up your motion. What was the square footage of the house?
Jill, can you let us know?
Unfortunately, I don't know the exact square footage at this point. It is a 4-bedroom house, 3 baths, colonial. I don't have the accurate square footage. I'm sorry, Your Honor.
All right, give me a moment. That's something that can be readily obtained. Give me one moment. I'm gonna go off the record.
Your Honor, if I may, 3,412.
Thank you.
All right, we're recalling 2403881 LT. All right, I've reviewed the escrow order. So Ms. Zolna, there are very few houses that are for rent in Huntington Woods. Very, 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 very few. This is an exceptionally large house for the city. It's on one of the largest lots in the city. Most likely it will sell for more than what it's valued at. However, typically we see houses around 1,800 square feet that are for rent in the city. And there's, again, it's just a handful of them. Rent is anywhere between 2,200 and 2,800. I'm gonna, given the square footage of this house, I believe the rental value would be somewhere around 3,500. However, I'm not going to enter an order for escrow. The writ is in effect. So Ms. Zolna, just send in the order that the motion to stay and the motion for reconsideration is denied. The writ stands. It can be immediately effectuated. That just means you have to get the order in and contact the court officer.
Thank you, Your Honor.
All right, everyone have a good day.
You too.
Neil, do we have anyone else ready?
Julie can log off.
Okay, thank you.
Yes, you're all set.
Bringing in Marion and Larry Britt.
Hello? Hello?
All right, 1 second, Miss Britt.
Oh, okay.
All right, give me a minute. All right, Neil, did we have anyone ready?
Marion, Britt, and Larry. Britt.
The Brits? Okay.
Miss Lacy hasn't attached yet.
I'm sorry, Neil, what was that?
I haven't been able to get Miss Lacy. She's coming in. Yeah, you should be all set, Your Honor.
All right, this is 2403190. This is the Loop Apartment Community LLC versus Marion Britt and Larry Britt. Miss Lacy, let's start with you.
Morning, Your Honor. Gabriel Lacy, P79685 for the Loop on Greenfield.
And Miss Britt, would you please state your name for the record?
Marion Britt.
And Mr. Britt, would you please state your name for the record?
Larry Britt.
All right, we're here today for our second hearing. I do have some information from the Brits regarding the rental assistance that was applied for. And it looks like there wasn't any access to immediate funding for the Brits. Miss Britt, let's start with you. Is there any other information for the court regarding rental assistance that you have?
No, they could, other than, what I applied for, and they told me that they didn't have any funds available. So that was the only thing.
Okay. Okay. All right, Miss Lacy, do you still have a balance?
I do, Your Honor. This time, the rent to retain possession is $2,024.32. Court cost of $157. The total balance owed is $2,024.32.
Well, so that's like, I'm just saying, I think that's the one.
All right, Miss Britt, we'll start with you. Do you agree with the balance?
Yeah, yes, apparently due to the court costs. Yeah, I had 2180, but I'm sure that's not including the court costs.
So it looks like they have the rent to retain slightly less than that. So it's at the 2021, but you do have the court costs at what that 157. Mr. Britt, do you have anything to say regarding the balance, or do you agree with it also?
Yeah, I agree with it also.
All right. All right. And did you have any plans regarding payment of rent?
Yes, I'm definitely trying to get that taken care of as soon as possible. You know, like I said, you know, my son, they dropped his part-time and now they cut his hours, and I'm just doing my best to try to get that caught up as soon as possible.
So, Ms. Britt, so here's the deal. The plaintiff is entitled to a judgment today. By law, they get 10 days so they can seek a writ of eviction. Sometimes when the tenants can tell us that they, have a firm date in mind that's not too far away, sometimes Ms. Lacey will work with us on a writ date. I obviously can't force them to do that. Do you have any firm date that you believe you could be caught up by?
No, I don't have a firm date, but I would definitely try to talk with the loop and try to work something out.
All right, well, that will be between you and your landlord. At this time, Ms. Lacey, there's a judgment by hearing. It's possession only.
Your
The
Honor,
rent retains the
Your
2000.
Honor,
Yes.
I
Yes, Ms.
hate
Lacey.
to interrupt you, but
Yeah,
I just
go ahead.
saw an error, and that's
Oh,
on me.
okay.
So the rent to retain is correct at the 2024 32.
Okay.
But I didn't add the court cost properly. The court cost is 188 and 43 cents. So the total amount owed is $2,212.75.
Okay. I was worried you were going to tell me you were 2,000 off. All right.
That would be lovely.
Oh my goodness. Okay. All right. All right. The plaintiff is entitled to a judgment today. This is by hearing. It is possession only. The rent to retain is the $2,212.75. You can get the writ in 10 days. That would be January 25th, I believe.
Yes, January 27th, Your Honor.
All right. And Mr. and Ms. Britt, you do have 10 days to appeal. If you are trying to work something out with your landlord, that is between you and your landlord now. Okay.
Okay, thank you.
All right. Good luck.
Thank you.
Yeah.
Can we do Epperson? That's the one
Yes,
that
we
Nick
can.
talked to. Neil, can you bring in Miss Epperson?
Is she in my file or paper?
Um,
Miss Epperson, can you hear me?
Yes, I can.
Hi, good morning. Before I call your case, we had some communication. I understand that you had been communicating with DHS. Did you talk to them again this morning already, or were you still waiting?
Yes, I spoke with them this morning at 8 a.m. I was told that she would begin working on my SCR relief and that someone would be in contact with me tomorrow. She did ask that I provide results from today's court hearing and scan and upload them so that they can be reviewed.
When you say results, are you talking about some places need a judgment, some places don't? Did they what kind of language did they use with you?
I wanted to clarify with her and she didn't specify. She did say that because I would be talking to you, I might not get anything from Zoom. So she just assured me that she would continue working with it and someone else might be picking up the case.
All right, Mr. Gentleman, I'm going to call this case as soon as I can get my file to allow me to access the notes. So
Sounds good.
just All right, this is case number 250056LT. This is Propel Property Management versus Epperson. All right, Mr. Devlin, can I get your appearance, please?
Your Honor, Adam Devlin, P72877 for the plaintiff.
Ms. Epperson, would you please state your name for the record?
Janelle Page Epperson.
All right, good morning to you, ma'am. This is your first pretrial for non-payment of rent. You do have the right to hire and consult with your attorney. We do have Lakeshore Legal Aid present today. They're free legal counsel. I don't know if you would qualify for their assistance, but if you want to speak with them, I will allow you to do so. And let's see, it looks like this is our first hearing, correct, Mr. Devlin?
Yes, Your Honor.
All right. All right. And if you do want to speak with Lakeshore Legal Aid, it sounds like you're already applying for rental assistance. But if you want to speak to them after this hearing, I'll just put you in a waiting room until somebody's available to screen you. Just let me know if you want to do that. You are entitled to a jury trial if you assert that today or within writing within 5 days. You also might be entitled to a conditional dismissal instead of a judgment if that's something that you can work out with your landlord and your landlord's attorney. Mr. Devlin, can I get the balance, please?
Your Honor, the balance in this matter is $1,811.40. That is inclusive of the $261.40 in court costs.
All right, Ms. Epperson, is there any issue with the balance?
My monthly rent payments are expected to be $2,000. I did lose my job right before Christmas on December the 19th. I also lost my last paycheck that was withheld with a sign-on bonus that I had budgeted for places like rent, utilities, my children's birthdays and holidays. I am a single mom. I was working full-time. I did receive a new full-time job offer that doesn't start until the end of the month. Between losing my job and now I have been able to borrow, find money to make some payments towards the balance. So the balance is less than the monthly rent, and I do still have efforts to continue to pay on the balance and get it back in the clear.
All right, so Ms. Epperson, since you've represented the court that you have already filed for rental assistance, you're way ahead of the game. You're way ahead of everyone else that I've seen in the past several days. So it looks like you're already working towards getting that balance down. You're entitled to an adjournment because you've already applied for rental assistance. The only thing that I need from you is I need you to send proof in that you have applied. Make sure you put this case number on it and we'll put it with the file. It triggers a 28-day adjournment for you. I do want to tell you, though, that if rental assistance is not secured by the next time I see you, Mr. Devlin will be entitled to a judgment. So it's going to be a short amount of time to make sure that you secure the assistance, or if you're able to. Let me give you the court's email so that you can send in the proof that you've applied. Are you ready?
Yes, ma'am.
So it's going to be C as in cat, I as in igloo, V as in vase, I as in igloo, L as in law, at 45, D as in district, C as in court.org. So civil@45dc.org. Do you want to read me back what you have?
Yes, I have civil@45dc.org.
Correct. All right. And we're going to schedule a hearing date for you that will come to you in the mail. Mr. Devlin, is there anything that you want to put on the record today?
No, Your Honor.
All right. All right. Good luck, Ms. Epperson. We'll send you a date.
Thank you, Mr. Powell.
All right. Do we have anyone else ready?
Your Honor, do you want to do that 21-930 Whitmore?
Your Honor, I can do my defaults too.
You still have Johnson here and Brooks.
Oh, never mind.
Are they with Lakeshore Legal Aid or?
I guess Nicole Johnson wants to speak to Lakeshore. Brooks, I never got to ask. I couldn't get them to connect, so I could bring them in.
All right, let's see if Brooks needs to go into a queue.
Yeah. No, Mr. Brooks? Mr. Brooks, can you hear me?
Yes, can you hear me?
Yes. Hello.
Mr. Brooks? Good morning. This is Judge Horowitz. We do have Lakeshore Legal Aid here. They are free legal counsel. I do not know if you'll qualify for their assistance, but if you would like to be screened, I can put you in a waiting room till we can get someone with you. Did you want to get screened today?
Yes.
All right, sir. All right, just be patient with us. We're going to put you back in the waiting room, okay?
All right. Thank you.
All right, let's bring in Mr. Chianis, his client. And did the defendant get screened or want to be screened?
Jones.
Neil, do you know if Jones wanted to be screened or if we're ready to go on that?
Oh, he's
He's
with
out with Falick right now.
Ah, okay. Okay. Hi, Mr. Chanis. It looks like Jones is out with Falick.
Ah, okay.
Your client is here. Did you need to meet with her?
If you want to put me in a breakout room with her, I'll talk to her.
Okay, just remind her kindly not to drive while she's on the record.
I will do.
Thank you, sir.
Thank you.
Neil, can I go in the breakout room with Miss Clark?
Okay.
Good morning, Judge.
Good morning, Mr. Jima. By any chance, are we ready on Mr. Lumumba's case?
Mr. Lumumba, Riggins is asked to speak to Lakeshore.
Okay. All right, Neil, I'll patiently wait. You tell me when you're ready.
All right. I think we're just kind of stuck right now until somebody frees up here.
Okay, that's okay. I'm going to update my notes and just let me know when you're ready.
Okay. Ms. Housey?
Yes.
Hey, ma'am. I believe you told me
Yes.
you didn't need to speak to Lakeshore, right?
No, I did want to speak with them.
Oh, you do? Okay. The first one, Your Honor, is going to be AIM 1 cleaning.
All right, do we have Ms. Lacy here?
Get her to answer. Miss Lacy?
Yes.
All right, this is 2403-188. This is a Loop Apartment Community LLC versus AIM-1 Cleaning Services LLC. We're here today for our second hearing date. Last time there was a Mia Williams present, who was the owner of the LLC. We adjourned the first pretrial to give her an opportunity to get counsel in this case. She has not appeared today. No other representative from this LLC has appeared today. Go ahead, Ms. Lacy.
Thank you, Your Honor. At this time, we will be moving, Gabriel Lacy, P79685 for the Loop Apartment Community. And at this time, we will be requesting a default judgment for possession only, where the rent to retain possession is $1,830.29. Court cost of $175.04. Total balance owed is $2,005.33. Looking for a pay or vacate date of January 27th, 2025.
All right, default judgment will issue for possession only, rent to retain for the amounts placed on the record. Your writ date is going to be January 27th.
Thank you, Your Honor.
The next one, Your Honor, is Generette.
All right, Neil, did you say that the Generate case was ready?
No, they're failed to appear.
Okay, so it's ready. All right, I think we have got Ms. Lacy here. All right, this is 2403-196. This is the Loop Apartment Community LLC versus Janelle Generate and Joseph Generate. All right, Ms. Lacy, may I get your appearance?
Gabriel Lacy for the Loop. And Your Honor, this case is dismissed, and I'll be submitting it.
All right.
Actually, I have another one that's dismissed, if you want to call it.
Okay, great. Just for the record, this case is dismissed without prejudice, and we'll wait to get the order. And what's your other one, Ms. Lacy?
The other one is 2403-196 LT. The Loop versus, wait, that's the one you just called. Sorry. It's 2403-202 LT. Alana Jeter and Demetrius Brand.
Oh, you think it's on the waiting room? Neil, did we see Demetrius Brand or Alana Jeter in the waiting room?
They're here.
This This is 2403202. This is the Loop Apartment Community versus Alana Jeter and Demetrius Brand. Miss Lacy, can I get your appearance?
April Lacy for the Loop Apartment Community.
And Ms. Clark, you want to state your name for the record? Oh, I'm sorry, Miss Jeter.
Alana Jeter.
The Jeter's on the phone. All right. And is Mr. Brand with you?
Yes.
Mr. Brand, would you just state your name, please, sir?
Demetrius Brand.
All right. And Miss Lacy, I think you had a motion.
Yes, Your Honor, this time the defendants have vacated the premises, so we are moving to dismiss this case in possession only.
Okay. All right. Case is dismissed without prejudice. All right. Ms. Johnson, I see you there. Did you need to say something?
Oh, yeah, both of them, they moved out already, so that's why this is no longer resident at the Loop.
Okay, that's just fine. Ms. Johnson, would you just state your name?
Oh, Ebony Johnson, I'm sorry.
All right, thank you. All right, Ms. Jeter and Ms. Brand, this case has been dismissed without prejudice. You're all set. Have a great day.
You too.
I need to check a phone real quick, Your Honor. Hello, people on the Samsung, can I get your name, please? Hello, persons on the Samsung, can I get your name?
Are you talking to me?
No, Ms. Clark.
No, Ms. Clark. We're just trying to identify a person on the phone. Just give us a moment.
Oh, okay. Okay.
Hello, person on the Samsung, can I get your name, please?
Apologies if I hope I'm not interrupting, but if Neil could put me in a break room with Neil Chanis, is he available?
We do have him here, yes.
I am available.
All right. All right, we'll put you together. Orton Clark, who's for the plaintiff here?
Miss Haddad and Mr. Yatuma spoke with Miss Clark.
All right, I see Miss Haddad there. All right. And is Mr. Yatuma available?
I am here.
All right. All right. Okay, this is 2403772. This is Versailles Barrett's Apartments versus Washington. Ms. Haddad, can I get your appearance, please?
Wait, Clark?
I'm sorry, Your Honor.
Oh, I
think that's
apologize.
the wrong case.
Give me just one moment. Sorry, my file's not catching up. All right, this is 2403746. This is My House of Detroit versus Clark. Attorneys may get your appearances.
Yes, Judge. Good morning, Ronnie Haddad, P4927 for the plaintiff.
Good morning, Your Honor. Zayda Tuma with Lakeshore Legal Aid. I will be filing an appearance on behalf of Ms. Clark in this matter.
All right, and Ms. Clark, would you please state your name for the record?
Chanel Clark.
All right, good morning to all the parties. We're here today, Ms. Clark, for your first pretrial for non-payment of rent. You do have the right to hire and consult with your own attorney. It looks like you've taken advantage of Lakeshore Legal Aid today. Mr. Yatuma will be filing an appearance. You have the right to a jury trial if you assert that today or within writing within 5 days and pay the associated costs. You also might be eligible for a conditional dismissal instead of a judgment if that's something that your attorney can work out with the landlord and the landlord's attorney. All right, Ms. Haddad, can I get the balances you have it?
Yes, Your Honor. The balance is currently $1,171.14 in rent to retain, $184.99 in attorney fees and costs, for a total redemptive amount of $1,356.13. I have spoken to Brother Counsel, and we have agreed that we're going to try to facilitate a resolution on this. So we would be requesting an adjournment on this to facilitate some type of resolution, Your Honor.
Okay. Mr. Yatuma, will she be applying for any rental assistance?
Yes, Your Honor. So my client will be applying for rental assistance as well. She is disputing the balance. And it looks like I was off by $100, but maybe I just didn't hear Ms. Haddad. Yeah, so Ms. Haddad and I will be in communication. She's going to send me a copy of the ledger and lease, and hopefully we can get that matter resolved prior to the next court hearing.
All right, Ms. Clark, we're going to schedule another hearing date for you. I'm sure Mr. Yutuma explained to you that he's going to send you some paperwork. Make sure that we get that within 5 days. It does affect the timing of your case. And we'll wait to receive that from you. Please put your case number on what you send to us, all right, with your proof.
Okay. Thank you.
All right, good luck, Ms. Clark.
Thank you.
Thank you, Judge.
Mr. Yutuma, I'll put you out with Mr. Globe.
Sounds good.
Person on the cell phone, can I get your name, please? Person on the cell phone, can I get your name? You're muted. Unmute yourself.
Mute. Okay, there we go, Your Honor. Oh, Lordy Lord.
What's your name? Are you Miss Lumumba?
Oh, that's my attorney calling me. Yes, Neil.
She's Dorothy Domble, I believe.
Right.
I got it. Can you see me, Your Honor?
No, you're not.
Yes, we can see you, Ms. Domble. Go ahead and mute yourself and go ahead and take Mr. Tanis's call, okay?
Yes, Neil.
You there?
Yes.
Ma'am, make sure you mute yourself. There you go. All right.
Your Honor, I do have Mark Holmes that failed to appear. He's one of Levine's, and also Courtney Hurt for Levine.
You want to go ahead and do Holmes? Oh, all right. Get Ms. Lacy here to do Mr. Holmes's case. All right, this is 2403198LT. This is the Loop Apartment Community LLC versus Mark Holmes.
Gabriel Lacey, P79685 for the Loop Apartment Community.
Okay, so it looks like the defendant has failed to appear. Just give me one moment. I do see that the defendant sent him proof of application that he applied for rental assistance. However, there is a letter asking him for further action, but he has not appeared today. Do you have any information, Ms. Lacy?
I don't. I do know that he had mentioned something about the heat, but that was resolved back in December. He hasn't made a payment since September.
Okay. All right. Go ahead, Ms. Lacy.
Thank you, Your Honor. So at this time, we would be requesting a default judgment for possession only, where the rent to retain possession is $4,795.04 for a cost of $175.04. Total balance owed is $4,970.08. And we are asking for a pay or vacate date of January 27th, 2025.
All right. Default judgment, possession only. Rent retained for the amount stated on the record. You can get your rent January 27th.
Thank you, Your Honor.
Brittany Hurt was also there too here.
All right, this is 2403200LT. This is a Loop Apartment Community LLC versus Courtney Hurt. All right, attorneys, go ahead.
Gabriel Lacey for the Loop.
All right, we haven't seen Ms. Hurt today. I had an indication that she was going to apply for rental assistance. She also stated last time that she would pay by December 27th. I don't know if there were any payments made. All right, we have not seen her today. Go ahead, Ms. Lacey.
Thank you, Your Honor. For the record, I do not have any payments made since November. We are requesting at this time a default judgment for possession only, where the rent to retain possession is $3,867.33. Court cost of $175.04. Total balance owed is $4,042.37. We're asking for a pay or vacate date of January 27th, 2025.
All right, default judgment, possession only, rent to retain for the amounts placed on the record. You can get the writ on January 22nd.
Thank you, Your Honor.
All right, Mr. Chance, I take it we're still waiting on.
No,
Mr.
I
Bailiff?
spoke with Ben. I think Ben just needs to go back if his client is still here to talk to.
If I can just have a minute with Mr. Jones, then we'll be able to put our consent
agreement
on the record.
Okay.
Your Honor, I've had Leonard Jacob here, and the other person to his complaint has not showed up, Hoffman.
Neil, can I go in the breakout room with Miss Lacey and Miss Ebony Johnson as well?
Okay.
Thank you.
Give me just 1 second. Mr. Jacob?
Yes, sir.
Give me just 1 second here, sir. Your Honor, Mr. Jacob has appeared, but the other party in his complaint, Mr. Hoffman, has not.
All right, Mr. Jacob, give me just 1 moment. All right, this is case number 240369 LT. This is Jacob versus Hoffman. Mr. Jacob, can I get your name for the record, please?
Leonard Jacob.
All right, give me just one moment. It looks like the defendant has failed to appear. I just need to check on the proof of service.
Excuse me.
All right, Mr. Jacob, it looks like you have service by attachment and a second mailing. All right, and Mr. Jacob, anything you wanted to put on the record today? How much rent is due and owing?
Your Honor, it's over 11,000. Probably
Mr.
more.
So,
Sorry.
Mr. Jacob, I'm going to give you a judgment today, but I need the rent that's due and owing, and if you have any court costs that you're requesting.
Just 1 second, ma'am, and I'll give you exact rent.
Okay. And Mr. Jacob, we're going to go off the record just while you look for that. And Mr. Chaniso, were you ready on your case?
I believe so.
And we'll recall Mr. Jacob's matter momentarily.
Your Honor is $12,800.
Oh, Mr. Jacob, hold on just 1 second. I'm gonna call another matter real quick. I just also want you to double check your court costs and make sure that you give me the total when I call you back. Okay?
Yes, ma'am. Yes, Honor.
Why are you doing things? Okay, this is 2403700. This is 21930 Whitmore LC versus Jones. All right, attorneys, may I get your appearances?
Yes, for the record, Neil Chanis, appearing on behalf of the plaintiff.
Ben Phelan. Yes, I will be filing an appearance to represent Mr. Jones. Mr. Jones, could you state your full name for the record?
Wesley Earl Jones.
Thank you. So
All right. Sorry, Mr. Jones, I just wanted to give his rights before you let me know if you've worked something out. Mr. Jones, you do have the right to hire your own attorney in this case. It looks like you've taken advantage of Lakeshore Legal Aid. Mr. Falick will be representing you and filing an appearance. You have the right to a jury trial if you assert that today or within writing within 5 days and pay the cost. You might be eligible for a conditional dismissal instead of a judgment if that's something your attorney can work out with your landlord and landlord's attorney. Mr. Chanis and Mr. Falick, I know that you took some time today. Was there a resolution?
Yes, Your Honor.
All right, go ahead.
Your Honor, we've agreed to terms of a consent order for conditional dismissal. This is a termination of tenancy. Mr. Jones will vacate the property on or before February 15th, 2025. The consent order will also indicate that the parties should communicate through their attorneys except for regular maintenance issues.
Give me the vacate date again.
February 15th, 2025.
All right, and Mr. Falick, is that the agreement?
That is correct.
Who's going to be preparing it, and how are we handling signatures?
I will prepare it and submit it. And Ben, do I have permission to sign it? Do you want to see it beforehand?
If you could send it to me, since I also have to file my appearance, I can upload them both electronically.
Perfect. All right, I'll get it over to you in a few minutes.
Thanks.
All right, and also, well, Mr. Jones is represented by counsel. You have well, it's a conditional dismissal. Okay, all right. Thank you, Mr. Jones. Mr. Chance, Mr. Frederick, just so you know, with my file, and we're off the record, I can't see everything. I have to go into each case jacket and each thing that was
Your Honor,
filed.
we're off the record. We're still on YouTube. If that's part of
no, that's fine.
Fair enough.
No, we're
Okay.
not going to. No, I just want you to know
yes,
that
of course.
you know, even if it's a termination tenancy versus non-payment of
Non-payment.
rent.
Mhm.
That's also something that doesn't show up on the first
Oh,
page.
okay.
So just so you know, going forward,
Got it.
the
We'll make
system's
sure- we'll
wonderful.
make
It's
it clear.
working. It's working well. All right.
And Your Honor, if I'm recalling from the last conditional dismissal, you have some verbiage you want it to say that would be reinstated with notice if.
Yeah, so Mr. Tanis is here enough to know that even if,
Okay.
no matter what boxes are
Right.
checked, that we require service to the defendant if there's a default.
Okay.
Right, reinstatement. Okay.
All right.
We add it if they don't. Okay, thanks.
Fair enough.
Thank you, Your Honor. Thank you, Ben.
Thank you.
Have a good day.
Court Officer Gensler, is there anyone else waiting to speak with an attorney?
I always have somebody. Give me this.
Of course.
Yes, Mr. Yatuma.
I'm ready on Miss Globe's case. We can proceed.
Okay, Ms. Globe, it'll be just 1 minute, okay?
All right, this is 2403197. This is Amani. This is the Loop Apartment Community LLC versus Amani Globe and Jalea Lee.
Yeah.
All right, Mr. Lacey, Miss Lacey, let's get your appearance.
Good morning, Your Honor. Gabriel Lacey for the Loop Apartment Community.
Mr. Tuma, are you filing an appearance?
Good morning, Your Honor. Zaydi Tuma with Lakeshore Legal Aid. I will be filing an appearance on behalf of Miss Imani Globe only. And I did have an opportunity to speak with Miss Lacey regarding this matter, and we have agreed to enter into a conditional dismissal. We're going to stipulate to convert this matter to termination of tenancy with a vacate date of January 31st, 2025 for Box 4B and Box 7 as checked. And Miss Lacey, do you want me to add language for defendant 2, just stating that they have failed to appear and then the same conditions will apply?
Yes, to a
Because because the defendant 2 is someone who co-signed and they're on active military duty, so that's why they're not here.
I see. Okay. All right. I'm sorry, Mr. Jaimie said you're going to be preparing that conditional dismissal.
Yes, Your Honor, I'll prepare the order and I'll send it over to Miss Lacey for signature.
And I apologize. Give me the vacate date again.
No problem. It's January 31st, 2025.
Okay. All right, Miss Globe, was that the agreement in this case?
Yes.
All right, you are all set. Anything else for the record from either party?
Not for me, Your Honor.
Nothing further.
All right. Thank you. All right, Ms. Jacob, Mr. Jacob, I see you there. Let me get back into your file.
I'm good to hang up.
Oh, you too, Miss Lacy. Are you done, Miss Lacy? I've still got Jackson and how's he?
I'm not going anywhere, Your Honor. That wasn't me.
Oh,
Miss Globe. Yeah, Miss Globe, you all set.
Thank you.
All right, Miss Globe. Have a great day. All right, recalling 240-369 LT. This is Jacob versus Hoffman. All right, Mr. Jacob, what is the amount of rent and your cost, please?
$12,800, Your Honor.
And is that just the rent or is that with your costs?
That's just the rent. The cost,
And what are your
I'm not
costs?
worried about. Not worried about the cost, not gonna add it.
Okay. All right, default judgment will issue for possession only. Rent to retain will be 12,800. Your writ date will be January 27th. All right, anything else for the record?
No, Your Honor. Just when should I expect them to be service that they have to evict?
So you'll be able to come get the writ on January 27th. So have the 10 days.
Okay.
All right. I think you have one more matter. Do we have the defendant here for that case?
I have not seen her. I'm not sure if she's right now.
Okay. Neil, did you see Miss Johnson anywhere?
Tiffany Johnson. There's a Nicole Johnson here.
Oh, is that a
But there's a Nicole Johnson.
No, I haven't seen Tiffany.
Okay.
Okay. Are you ready with your rent for Miss Tiffany Johnson?
Yes, Your Honor. $11,200 and no cost.
All right, let me just call the case. Give me just 1 second. All right, this is 240-3690. This is Jacob versus Johnson. We have not seen the defendant today. And Mr. Jacob, give me one moment. I'm just checking the proof of service. And it looks like you have personal service. All right, judgment will issue for possession only. Mr. Jacob, what is your judgment amount?
11,200.
All right, the rent to retain will be 11,200. You can get the writ on January 27th. Anything else for the record, Mr. Jacob?
Thank you, Your Honor. Just a reminder, I have a lot of cases. Remember, I'm sure you remember me, and I'm trying to solve them. These are two of them.
Okay. All right. Well, I'm sure I will see you back.
Yes.
Have a great day.
Thank you. Bye-bye.
Mr. Washington? Mr. Washington?
Yeah, sorry.
Hi, I was just going over my list here. You still want to speak to Lakeshore, right?
Well, not if I don't want to.
All right. Well, let me bring you in for your case, and then you can decide. Okay.
Okay, sounds good.
All right. Sarah Reed is here for Politz.
Ms. Reed, you here for Versailles Barrett's?
Yes, good morning, Your Honor.
All right, this is, oh, I'm sorry, Mr. Washington, were you working with Lakeshore Legal Aid at all today?
So I was, I don't believe I need them. I spoke to the leasing office, and I'm all caught up and paid for. I only have a small balance for January's rent, and
Okay, let's
I'm
get on the
paying it
record
today.
and Mr. Washington, if at some point you decide that you need some assistance, we'll let you have that, okay? All right, this is 2403772. This is Versailles Barrett's Apartments versus Washington. Ms. Reed, can I get your appearance, please?
Thank you, Your Honor. Sarah Reed, REG, appearing on behalf of the plaintiff.
All right, Mr. Washington, would you state your name, please?
This is Jamaria Washington.
All right, Mr. Washington, this is your first pretrial for non-payment of rent. You do have the right to hire and consult with your own attorney. We do have Lakeshore Legal Aid present today. They are free legal counsel. I don't know if you would qualify for their service. If at some time you decide you want to be screened, let me know and we'll make that happen. You have the right to a jury trial if you assert that today or within writing in 5 days and pay the associated costs. You also have the right to a jury, or you have the right to a, you might be eligible. It's been a long morning. You might be eligible for a conditional dismissal instead of a judgment if that's something you can work out with your landlord in this case. Ms. Reed, what is the balance that you have?
Your Honor, the balance that I have, including court costs, is $1,741.51. So I don't know if he's made a payment recently, but that's basically, well, that's what I'm showing is the balance currently.
All right.
Yep.
Mr. Washington, you're doing better than I if you think that's a small balance. All right. All right. Did you make any recent payments?
Yeah. So I only owe $731 as of today, and I'm paying it this evening with my direct deposit lease.
Okay, so let me ask you this. When was the last payment made?
Last Friday or Thursday. I paid $1,000.
Okay,
Ms.
that
Reed,
sounds about
do you
right,
have-
Your Honor. If he paid I don't have that. If he paid $1,000, that brings him down to $741. There might be a late fee on there, but I don't have that on my ledger yet. But so I don't know what, Your Honor. I apologize. I don't normally handle the Oak Park docket. I don't know if we want to adjourn this for a week or two, and then he'll probably have it paid. Or
yeah.
All right. So
it'll be
I
paid
would.
this evening.
Okay, so hold on, Ms. Washington. I appreciate that. Ms. Reed, I appreciate you being willing to give him some time to get caught up based on his representations. I'm going to schedule a hearing for you. It will come in the mail, Mr. Washington, so make sure you're looking for it. Make sure that if you get a date from us, you appear. Sometimes tenants think that they've settled it, and then they haven't, and then a default judgment issues. So if you do get a date from us, just make sure that you appear, okay?
Okay, sounds good.
All right, you're all set. Good luck.
Great, thank you.
I think that's my only one this morning, Your Honor. Have a good day.
Have a great day, Mr. Reed.
Thanks.
Your Honor, it looks like Miss Bird is ready with Mr. Falick.
Okay.
Mr. Callahan here.
Do we have Mr. Callahan? All right, this is 2403688. This is Reserve Management Company versus Bird. Mr. Callahan, we'll start with you.
Kevin Callahan for plaintiff P78273.
All right, Ms. Bird, would you state your name for the record?
Hi, good morning, Your Honor. Cecilia Bird.
All right, Mr. Falick, are you filing an appearance in this case?
I will be filing an appearance to represent Miss Bird. I know she's made a couple of recent payments, but will be seeking rental assistance, and I will make sure that she gets her proof of rental assistance application filed and be in touch with Mr. Callahan to make sure we have the documents straight. Maybe she can actually get some help.
All right, Ms. Bird, let's just go over your rights real quick. You have the right to hire your own attorney. Looks like you're taking advantage of Mr. Falick's services from Lakeshore Legal Aid today. You have the right to a jury trial if you assert that today or within writing within 5 days and you pay the costs. You also might be eligible for a conditional dismissal instead of a judgment if that's something you can work out with your landlord and your landlord's attorney. Mr. Callahan, just so we're all on the same page, what is the balance that you currently have?
Currently, the month of January is $2,800. I am emailing a copy of that ledger to Mr. Falick right now.
Okay. All right, Mr. Falick, any issues that we should be aware of?
None.
All right. All right. We're going to schedule a hearing date, Ms. Bird. That's going to come to you in the mail. Make sure that when you send the proof that you've applied for rental assistance to us within the next 5 days, that you put this case number on it so we know where to file it. Okay.
Yes, I have one question. Is that included with the 2 payments that were made for this month of a total of 1,000?
Yes, I received 2, or my client received 2 payments, one on the 3rd of January for $500 and one on the 10th of January for $500.
Okay, thank you.
Thank you.
All right. Good luck, Ms. Bird.
Thank you.
All right. Thank you. Thank you, Kevin.
Thanks. Have a great. Do I leave now? I'm sorry.
You're all set, Ms. Bird, unless you just want to spend more time with us.
Oh, no. Okay.
You get the rest of
guys
your
have a
morning
great
back.
one.
Stay
Thank you.
stay warm out there.
You too.
All
Bye-bye.
right. Anyone else waiting for legal advice?
I'm bringing Riggins in.
I think Mr. Lumumba has an attorney. Is Riggins ready, or did you need to talk to Mr. Riggins?
Yeah, she's ready. I'm trying to get her back.
Mr. Falick, did you need to talk to Mr. Lumumba's attorney?
Oh, I'm not sure what case you're referring to. I think maybe it's
I spoke with Miss Regents. I won't need to. She's gonna apply for rental assistance.
Okay.
All right, I'm gonna have to go out and get her, so I'll be right back.
Okay.
Okay.
Should I just put Mr. Falick in with,
Yes.
Mr. Vashon? Is it Nicole Johnson?
That sounds good. Right. There we go. Hi, Mr. Lumumba, can you hear me?
Yes, I can hear you.
All right, and I think you have an attorney with you. I have not seen him in the room yet.
Okay, Miss Riggins is in the courtroom.
Yes.
Mr. Lumumba's on the phone.
All right.
His attorney, Mr. Shanefield is there.
We have Mr. Shanefield here.
Hi, good morning, Your Honor.
There he is. All right, this is 2403764 LT. This is Lumumba versus Riggins here for no payment of rent case. All right, Mr. Shanefield, can I get your appearance, please?
Thank you, Aaron Shanefield, Goldstein, Burchett, and Freed on behalf of the plaintiff, Patrice Lumumba.
All right, Mr. Toomer, are you filing an appearance in this case or are you advice only?
Good morning, Your Honor. Zeta Tuma with Lakeshore Legal Aid. I'm appearing as advice only.
All right, and Mr. Riggins, can you hear me?
Yes.
Miss Riggins. So could you spell your last name for me, please? I have two different spellings.
Regins.
All right, and Mr. Shanefield, if you just make a note of the proper spelling.
I'm sorry, I didn't hear from the defendant. I apologize.
So I've got the spelling last name is Regins.
Yeah, and we had filed an amended complaint, and I believe it's spelled correctly on the amended complaint.
Let me see. I have your complaint.
My first name and middle name isn't spelled correct on the first complaint.
Do you want to give me your first name spelling, please, ma'am?
Aqusiha.
Aqusiha. Got it. All right.
And my middle name is Rense.
All right, I verified I do have your amended complaint, Mr. Shanefield. Thank you.
Thank you.
All right, Miss Riggins, this is your first pretrial for non-payment of rent. You do have the right to hire and consult with your own attorney. Looks like you took advantage of communicating with Lakeshore Legal Aid today. Mr. Utuma has provided you with some advice. You have the right to a jury trial if you assert that today or within writing within 5 days and pay the associated costs if given a second hearing. You also might be eligible for a conditional dismissal instead of a judgment. That will be between you and your landlord and your attorney to work out. All right, Mr. Shanefield, can I get the outstanding balance?
Thank you, Your Honor. Rent is $1,250 per month. Late fees $160 per month. Rent is owing from October 2024 through January 2025. When you add up the rent and late fees for those months, the total is $5,640. In addition, there's the defendant tenant is responsible for utility bills. There's an outstanding water bill of $332.51. Court filing fee, process server fees, etc., of $200. Attorney fees that are owed under the lease of $2,000, plus any additional supplemental rent that's owing. Currently, the grand total is $8,172.51. When I was just recently retained, we filed an amended complaint, an amended summons. All the defendants were personally served right away in advance of today's hearing. We would ask, due to the outstanding rent and large balance, we'd ask that the court enter a judgment for the full amount of money, judgment and possession, Your Honor.
Okay, all right. So the 2,000 attorney fees, Mr. Shanefield will have to address that at a later date. However, my understanding is that Mr. Riggins, Miss Riggins, I apologize. I can't see you, ma'am. Can you come into the camera?
I'm sorry.
You're fine. It just helps me keep the party straight.
I was crying, so I didn't want to be in the camera.
Oh, you're just fine, ma'am. I just want to make sure that I address you properly. Okay, so my understanding is that you're going to apply for rental assistance. Is that correct?
Yes, ma'am.
All right, and do you have any issues with the balance as stated?
Yes. I wanted to know, will my security deposit be deducted from that, which was $1,875, and also the original late fees was $100. They added $60 more to the late fees.
All right, so as to your first question, the security deposit is a separate issue. Right now, we're going to deal with the rent to retain. Do you have any issue with? I think the stated amount was $5,640 just for the rent. Do you have any issue with that balance for the rent?
The rent should have been like $4,400.
Okay, so I take it, Mr. Scheinfeld, that the balance that you gave me just for the rental portion of that included late fees?
Yes, Your Honor, the 5,640 is rent and late fees.
They added
All right,
more
and-
for the late fees.
Okay, so we'll get to that in just a moment. I just want to address the balances first, and then we'll talk about how to proceed. The utility bill, the water bill, do you agree with that?
Yes, $300.
Yes, ma'am.
It's actually
Yes.
332, Your Honor.
Yes.
Do you agree to that balance?
Yes.
Okay, and then we have the court costs. We'll talk about the attorney fees at our next date, Mr. Scheinfeld. All right. So
Can I
as to
add
your rent
something?
and your late fees, yeah, Mr. Schuman, go ahead.
Yeah, just for the record, per Michigan statute, the attorney fees are capped at $75 if a judgment is entered by hearing, and it's $150 if a judgment is entered by trial. So, and I think he
Yeah,
mentioned
we're not
$2,000.
at that phase today. We will
Okay.
make sure. I've made a note. We will address the attorney
Okay.
fees.
Got
All
it.
right. All right. So the first issue, any negotiation you want to do regarding your late fees, when we'll take a look at the lease at the next hearing too. But if you're trying to negotiate on the rental portion of it, ma'am, make sure that you're communicating with your landlord. Those are typically by contract, unless there's something out of sorts with your lease, which we'll go through at the next hearing. And then my understanding is that you're going to apply for rental assistance in this case. Is that correct?
Correct.
All right, so Mr. Utuma is going to send you some paperwork. The most important thing is that you submit proof to the court within the next 5 days that you have applied for that rental assistance. Please put our court case number, the court case number on your proof so we know where to file it, and you get the time that you are allowed to have, which will be the 28 days in this case. It's very, very important we get that within the next 5 days. Was there anything else that you wanted to talk about today, Ms. Riggins?
No, ma'am.
All right, Mr. Scheinfeld.
No, Your Honor, we have not received word or proof of any rental assistance, so we're a little concerned that we just don't want that to be a delay tactic here, Your Honor.
So, Mr. Sheffield, Mr. Utuma just met with her today. He's going to send her the paperwork today, and then she is required. She doesn't get the time unless she sends us the proof within the 5 days. There's actually no requirement the attorney receive the proof. I don't know why that is, but that's how it's written. So, as long as the court gets it, she will be afforded the appropriate time, and we'll schedule a hearing. We'll send that out in the mail.
Yep. Thank you, Your Honor.
Thank you.
Good luck, ma'am.
Bye.
Is there ready Nicole Johnson?
Mr. Paylor, you all set on Johnson?
Yes.
All right, this is 2403911LT. This is Adams Capital 2 LLC versus Johnson. All right, Mr. Devlin, can I get your appearance?
Your Honor, Adam Devlin, P72877 for plaintiff.
All right, and Mr. Falick, I see there, are you advice only, or are you going to be filing an appearance?
I will be filing an appearance to represent Ms. Johnson and helping her with the rental assistance paperwork.
All right, Ms. Johnson, would you state your name for the record, please?
Nicole Johnson.
All right, Ms. Johnson, this is your first pretrial for non-payment of rent. You have the right to hire and consult with your own attorney. Looks like you've taken advantage of Lakeshore Legal Aid. Mr. Falick will be filing an appearance on your behalf. You have the right to a jury trial if you start that today or within writing within 5 days if given a second hearing, and you pay the associated costs. You also might be eligible for a conditional dismissal instead of a judgment if that's something that you can work out with your landlord and your landlord's attorney. Mr. Devlin, would you give us the balance?
Your Honor, the balance. Oh, of course it didn't populate, so hang on.
My case jacket never populates, so my hearings are taking twice as long.
Your Honor, the balance is $6,650 plus costs.
Mr. Falick, any issue with that balance that we should be aware of?
Not that I'm aware of. That sounds about right. I just emailed Attorney Devlin to get a full ledger so that we can review it and use that in a rental assistance application. Otherwise, we'll just get everything filed and try to resolve this by consent.
All right, Ms. Johnson, just make sure that when you submit that rental assistance to the court that you put this case number on it so we know where to file it. We're going to schedule a hearing. That date's going to come to you in the mail. You're all set.
Okay, thank you.
Good luck.
Mhm.
We never saw Jonathan Jackson. It's one of Miss Lacy.
All right, Miss Lacy, you ready on Jackson? All right, this is 240-320 LT. This is the Loop Apartment Community LLC versus Jonathan Jackson. Miss Lacy, can I get your appearance?
Gabriel Lacy for the Loop, Your Honor.
All right, looks like defendant has failed to appear. Defendant was present at the last hearing, agreed to the balance, indicated they would submit for rental assistance. I do not have any proof of application in the file. Go ahead, Miss Lacy.
Thank you, Your Honor. At this time, we will be requesting a default judgment where the rent to retain possession is $5,953.81. Court cost of $175.04. Total balance owed is $6,128.85. We're asking for a pay or vacate date of January 27th, 2025.
All right, default judgment, possession only, rent to retain for the amounts placed on the record, but January 27th.
Thank you, Your Honor.
And did we ever see Halsey?
She's in a breakout room.
Yeah, she's in the breakout room right now.
Okay, and then I think I have Brooks and Bird left. Are
Brooks, Your
both of those
Yep,
gentlemen?
Ytum is out with Brooks in the breakout room. And Halsey's out with Falick.
Yeah, let's change that one, yeah.
All right, is this, Brooks?
Yes.
All right. All right, this is 2403908. This is Propel Property Management versus Brooks. Attorneys may get your appearances.
Your Honor, Adam Devlin, P72877 for the plaintiff.
Good morning, Your Honors. 82 Mobile Lake Shore Legal Aid appearing as advice only in this matter.
All right, and Mr. Brooks, would you state your name for the record, please?
Stephen Brooks.
All right, good afternoon to you, sir. This is your first pretrial for non-payment of rent. You have the right to hire and consult with your own attorney. Looks like you took advantage of Lakeshore Legal Aid, and Mr. Utuma has provided some assistance today. You also have the right to a jury trial if you start that today or within writing within 5 days, if granted a second hearing, and pay the associated costs. You also might be eligible for a conditional dismissal instead of a judgment, if that's something that you can work out with your landlord and your landlord's attorney. Mr. Devlin, can I get the balance as you have it?
Your Honor, the balance inclusive of costs is $2,690.12.
Okay. And do you agree with that balance, Mr. Brooks?
Yes.
And Mr. Utuma, you provided some assistance to Mr. Brooks today. Can you tell me what that was?
Yes, Your Honor. So I did have an opportunity to speak with Mr. Brooks, and he is going to apply for rental assistance. And I did advise him that he must submit a written proof to the court within 5 days. And I'll be sending him that information after court with instructions on how to submit the form to the court.
Okay. All right. So, Mr. Brooks, after Mr. Utuma sends you that and you apply for the rental assistance, just make sure that you send proof to the court within the next 5 days. Make sure that you put this case number on it so we know where to file it. And we're going to schedule another hearing date for you. That's going to come to you in the mail. Make sure you're watching for it. Anything else for the record from either party?
No, Your Honor.
All right. Good luck, Mr. Brooks. We'll send you a new date.
All right. Thank you.
All right. And then we have, do we ever say housing?
Housing is with Mr. Fay.
Okay. All right. Mr. Utuma, I take it, I think we only have housing left on Felix with the housing, so
I'm
save
sorry.
yourself. You can save yourself, I guess.
Yeah, Halsey should be the last one. She's always failing.
Yeah.
Are you ready for me, Mr. Muhammad?
Hi, Miss Lacey, you're not muted. Oh, you hear Mr. Lacey? There we go.
is it, if possible, could Attorney Lacy and I speak in a breakout room very briefly?
I can go back to room 11.
I could meet you there.
I'll put you in a room.
Oh, okay.
Okay.
Okay, Neil, if you could put Ebony into Ms. Lacy's breakout room so the two of them can speak briefly, then we should be ready to go.
Okay. You talking about Ebony Johnson or? Okay,
Yeah, Ebony Johnson from the Loop. Just there we go. That's And I think it probably maybe just have Miss Housey stay in the breakout room. I won't have anything to discuss with her until I get a response from Attorney Lacey. So we'll just sit tight.
Okay.
All right, I think you're it. That's it.
We'll be a minute, I think.
All right, right here.
Okay.
Ms. Lacy, you need to talk to Mr. Falick again.
Oh, I was just about to chat it to him.
Okay. Okay. Then if you could put me back just for a minute with Miss Housey, and then we'll come on. We can put our appearances on the record. Okay, if I think Miss Housey's on the phone, so I think Neil, you need to move her, and then Miss Lacy, I just emailed you back, or now I can guess we can chat.
And Miss Housey's in the courtroom.
Okay, thank you. I think we're ready then.
I've got to get back into my file, so give me 20 minutes. Something like that.
Gabe, do you see my chat?
Need my glasses because I'm old.
Yeah. They're stylish.
Yes, that's fine.
Okay.
Okay, this is 2403199LT. This is the Loop Apartment Community LLC versus Cheyenne Housey. All right, attorneys, can I get your appearances, please?
Gabriel Lacy, P79685 for the Loop.
Ben Falick will be filing an appearance on behalf of Miss Housey, who's here by phone. Miss Housey, can you state your name for the court record?
Jaimie Housey.
All right, it looks like everyone took some time to talk. I see that you did apply for rental assistance. Where are we at with this case?
So the rental assistance stay has expired. We've worked out the terms of a consent judgment that we can put on the record and file.
Okay, go ahead.
I'll defer to plaintiff's counsel, who's got the ledger.
All right, Ms. Lacy, go ahead.
Thank you, Your Honor. At this time, the rent retains possession is $6,597.27 for a cost of $175.04. Total balance owed is $6,772.31.
Okay. And what about the rent date?
January 31st, pay or vacate with if we can stipulate in advance to setting the judgment aside. I'm asking Attorney Lacy if we didn't get a chance to discuss a stip to set aside as an alternative to a conditional dismissal.
Oh, we can do a conditional dismissal where she vacates. That way nobody has to do any follow-up work if you want to do it that way.
Well, the conditional dismissal with January 31st as the date to either pay the full 67.72.31 or vacate.
I'm so sorry. So the conditional dismissal rent is the $6,770.31, and you're giving her until January 31st to pay it or move?
Pay or vacate.
Pay or vacate.
Okay.
She'll have the option, and the case can be. I'll explain, Miss Housey, how the conditional dismissal works, but it will be dismissed outright if you either pay or vacate by the end of the month, and otherwise you could be evicted at the beginning of February.
All right. Do you understand that, the Ms. Housey, you'll have until January 31st to pay the rent in this case or move?
Yes, ma'am.
And you do understand that if you do not pay or vacate the premises, what will happen is that they can come back, reinstate this case, and then they'll be able to proceed with eviction. Do you understand that?
Yes, ma'am.
All right. All right. And Mr. Falick, are you preparing that and sending it in?
I'll submit it because I also have to submit my appearance. So we'll make sure that we have everything in writing to match the terms that we put on the record and have that for you today.
Okay. All right. Thank you. All right, Ms. Housey, you're all set. Good luck.
Thank you.
All right, I think that concludes